Hello, everyone. Alicia Backman-Beharry, Canadian immigration lawyer at Holthe Immigration Law in Canada. In today's video, I want to address a question that causes lots of confusion when people are trying to complete their Express Entry profile or when they are trying to complete their application for permanent residence under Express Entry. The question is, can I claim job offer points? As an immigration lawyer, when I meet with clients, I always ask them, did you claim arranged employment points? Or did you claim that you had a job offer in Canada? Not all job offers are eligible to give 50 points or maybe 200 points to your CRS score. To be able to properly claim points under your CRS for a job offer, you have to be able to say that you have a qualifying offer of arranged employment. Now, what is a qualifying offer of arranged employment? The answer to what is a qualifying offer of arranged employment can be found in Section 29, Sub 2 of the Ministerial Instructions respecting the Express Entry system. So, what does it say? And how many points are at stake anyways? Well, you could get 200 points, but only if you fall under NOC 00. And that's true for the old NOC under the 2016 National Occupation Classification Code. It's also true under the new NOC 2021, the tier system. It's got to be a 00. Nothing else is going to give 200 points. But if you do have a high-skilled job under the old NOC 0A or B, or under the new tier system, tier 0, 1, 2, or 3, then listen on because maybe you will qualify for a qualifying offer of arranged employment. Okay, so if you fall in the category of having high-skilled work, it's not 00, but you're sure that it is high-skilled, then you may be eligible for 50 CRS points. 50 CRS points make a sizable difference in terms of your score if you're looking at the highly competitive world right now of Express Entry. What happens if you already have an Express Entry profile, or maybe you even already have an invitation to apply under Express Entry, and you realize after watching this video, I claimed CRS points for a job offer and I shouldn't have. I'm actually not qualified. The risk is if you have mistakenly claimed 50 points for a job offer in Canada, you could be out those 50 points as soon as an immigration officer picks up your file and actually reviews it, which may be months from now. The other problem is that that immigration officer might accuse you of misrepresenting your situation. Misrepresentation carries a 5-year bar and makes you inadmissible to Canada. You won't be able to submit another Express Entry application or any other type of application for permanent residence for a long time if you are found guilty of misrepresentation. If you want to avoid having your application for Express Entry refused because you actually don't have those 50 points, then listen on. The law is a combination of Section 29 Sub 2 of the Ministerial Instructions regarding Express Entry, and it's also referring to Section 82 Sub 1 of the Immigration and Refugee Protection Regulations. Here's what those sections say. Section 82 Sub 1 of the Immigration and Refugee Protection Regulations has 3 preconditions for all eligible job offers. Here's the first precondition. 1. All job offers have to be made by an employer that is not an embassy and an employer that is not on the ineligible list of employers. You can find this list of ineligible employers through the link in my article on our website at holthelaw.com. Here's the second precondition for Regulation 82 Sub 1. It must be continuous, paid, full-time, non-seasonal work in a high-skilled occupation code. So continuous means there can't be breaks in that employment, and paid means you have to have earned a wage, commissions, and hand, full-time is considered to be 30 hours a week at a minimum, and they won't count more than 30 hours in any given week. Lastly, it does have to be a high-skilled job. Here's the third precondition under Regulation 82 Sub 1. The employer needs to write a new offer of arranged employment. They need to intend to continue to employ you for 1 year after you get your permanent residency. And this is where many applicants fall down and don't meet the preconditions for arranged employment. Arranged employment is more complicated than it might seem on the surface. Only if somebody meets those three preconditions and also falls in one of the three following scenarios can they properly claim, yes, I have a valid job offer. Here's the first scenario. Scenario 1 goes like this. You have an employer who's a Canadian employer, and that Canadian employer has applied for a brand new labor market impact assessment, an LMIA, and they have named you on that LMIA, and they've specified the job, the working conditions, the location, and the wage, and it's all been approved by Service Canada. Here's what scenario 2 looks like. You're working in Canada for a Canadian employer who has already obtained an employer-specific LMIA-based work permit. Again, in scenario 2, your employer has to have already been approved for an LMIA, and you have to have a work permit that specifies that employer's name on the work permit itself. In addition, in scenario 2, you have to be authorized to work on the day that you actually submit your EAPR application or your electronic application for permanent residence under express entry. And you have to be authorized to work on the day that you get your landing as a Canadian permanent resident. So you have to maintain status the whole time. Not only that, you also still have to have had that new arranged employment letter from your employer indicating that they intend to continue to employ you for 1 year after you get your permanent residency. Here's what scenario 3 looks like, and everybody wants to try to fit in scenario 3 because guess what? Scenario 3 is the only scenario that allows people to have a work permit that does not have an LMIA to support it. However, and this is where almost everybody gets it wrong, an open work permit is not sufficient. It must be an employer-specific work permit. Here's scenario 3 in a nutshell. Scenario 3 says you have to have an employer-specific non-LMIA based work permit. These are very limited, usually under the international mobility programs. Not only that, you also have to have been already working for 1 year in Canada. It can be full-time or it can be an equivalent amount of part-time work that adds up to a year of Canadian work for that same employer on your work permit that is employer specific. And you also still have to have that new qualifying offer of arranged employment from your employer that's going to be valid, or they intend to continue to employ you for another year after you've obtained your permanent residency. So there you have it. There's quite a bit that's involved in properly claiming that you have a job offer in Canada. First of all, you have to meet those three preconditions of Section 82 Sub 1. Also, as confirmed by the federal court in Canada, there are some things to consider when you're looking at scenario 3. Remember, the federal court has confirmed that in scenario 3, you need a few things. 1, you have to make sure that you are working on an employer-specific work permit, not just any kind of work permit. The second thing is that you have to have an offer from the employer that is specified on that LMIA exempt employer-specific work permit. And the third thing is that you have to have accumulated in Canada 1 year of full-time or the equivalent in part-time work experience for that employer and still be working for that same employer. So after all that, the question is, how do you properly fill out your intended Work in Canada section on your Express Entry profile? Well, my friends, that's where I need to speak with you individually to make sure that I can provide you the proper legal advice. So, this video provides information, but not advice. If you'd like to speak with us, reach out. Please book a consultation with me. And also, we can be retained to assist you through the process to make sure that you are properly claiming arranged employment points, otherwise known as a job offer, in your Express Entry profile or your Express Entry application for permanent residency. And I hope by this point you've realized that there are preconditions that everybody has to meet before they will qualify for arranged employment points. Not only that, you also have to fit within one of the three scenarios that we've discussed today. This is a complicated area of immigration law, and many people get it wrong. Unfortunately, it can have really disastrous results because if people go on and accept an invitation to apply and they don't know that they actually don't qualify for those 50 points, it can result in huge delays and potentially losing your ability to become a permanent resident of Canada. Make sure that you reach out to us if you have questions about how to claim a job offer in your Express Entry profile. Thanks very much, everyone. My name is Alicia Backman-Beharry, immigration lawyer at Holthe Immigration Law.